for those. And we'll go ahead and get started. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging. I do a couple of things for them. I do housing navigation, which is more or less advocacy and education for affordable housing for low-income seniors and people with disabilities. But then I also do caregiver information services where we held events like this today, and we're very blessed to have Haiman+Hogue as a partner with this, and this is I think our fourth one, and another incredible topic, and so I hope you all enjoy it. There's a couple of housekeeping deals that we'll take care of here real quick. First, I'm going to let you, Sheila, talk about the CEUs if you would.
Thank you, Marty. And thank you so much for having these with us, because we love doing this. Education is our primary core value at Haiman+Hogue. So to educate, and especially all of the professionals that are on here, number one, I just want to tell you, this is Social Worker Month to appreciate social workers. I just want to tell you how much we appreciate what you do for others, because it helps us do our job better. Secondly, the CEUs, we're happy to give CEUs to nurses, social workers, assisted living managers, and licensed professional counselors. Any CEU that we do are good for all four of those areas. What it requires from you is that eventually when Marty sends a follow-up email, he will send you an eval and a sign-in sheet. You will return those to me, and then I will send you your certificate. Very simple. So we're so thrilled to be here today and offer this education, because, like I say, it helps you do your job, which your job is helping others, which helps us do our job. So thank you so much again.
Very good. And again, as Sheila said, I'll be sending out a follow-up email after today's webinar with that information for you, and both of those documents. I think there's actually three. One of the documents has to be signed by the people looking for, is that the assisted living, the conflict of interest?
Well, that was for nursing, and that's not going to be for this one.
Okay, that was specific to that one. I'm sorry. Right, okay, yes. Great, very good. Okay, and so that will go out in a follow-up email after we're done, probably an hour or so after we're done today. The other thing I want to make sure you all know is that this morning in your 1 hour reminder email, at the bottom, you should have had two links to copy and paste into your browser. One of them was for the handout, which is the 43-point checklist, and the other one is for the slides. If you did not get those by chance, I'm copying and pasting those into the browser as we speak, and you can copy, again, those are there, and you can copy and paste those into your browser to download either of those. The next thing I want to talk about, and this you'll get a survey for after we're done in the follow-up email. I set up a drawing this month. We are trying to get your feedback on topics that you would like to see us cover. And I know you all are busy, you know, COVID's kind of added a new dimension to everybody's work. And so everybody's pretty busy. And so what we're doing is I'm doing a drawing, and there will be a link that you can go into and put in the topic. You're gonna have to put in your name and email address, put in a topic. You know, we're looking for topics that are related to caregiving. They can be on the legal side, they can be on the medical side, they can be on the family caregiver side, but we're looking for the topic and then just a description of what you'd like to see covered in that topic. You can enter this as many times as you want. Every time you enter, your name will get put in again for the drawing, and this is going to run through the end of the month, and then the first week of April, we'll be drawing for 3 $50 Amazon gift cards, and we appreciate your help with this. So you will get this link again in the follow-up email. So Fred, I'm going to turn it over to Fred Haiman. Fred is a founding partner with Haiman+Hogue, and he's going to be presenting today.
Thank you, Marty. I appreciate that. Let's go ahead and get the slideshow going. I don't know if you have it.
Are you not seeing the slides?
All I'm seeing is the very first one, and it doesn't look like it's moving. It's just I'm seeing the presentation of, you know, when you look at it when you're working on the PowerPoint.
Okay, let me stop share and reshare and see if that will help. Sorry about
Okay.
that.
That's okay. It may be mine.
Now, what do you see?
Okay, I see. What does it mean for administration of estate?
That's where we're at.
All right.
So I'll back right up to here, and
Okay.
here's Fred's information. And again, you'll have that in the handout you have, but you go right ahead, Fred.
Well, thank you very much again, Marty. This topic is one of those topics that nobody wants to talk about, nobody wants to think about. Nobody likes to face the fact that we're going to pass away in our life or that we're going to lose people that we love. But the reality is, and we all know this, that it's going to happen. There's no way out of it. And we can either ignore it or we can prepare for it ahead of time. And that's what we do. As a disclaimer, this is what I do for a living. I am an estate planning and elder law attorney. Our firm does nothing but estate planning and elder law. And this is what we deal with every day. And this topic really means something personal to me, because I was a trial attorney for the first 10 years of my life, or my legal life. I was a police officer before I was a trial attorney, and then I was a trial attorney. And after I went through 10 years of trial work, working 60 to 80 hours a week, I got a disease called ulcerative colitis. And I know that most of you all are very familiar with it, but it got so bad that in 2006, they had to remove my colon completely. And when they did that, they built what's called a J pouch. Unfortunately, the doctors messed up. My J pouch ruptured. I was in critical condition for 10 days. I was in the hospital 37 days. I was told that I shouldn't have lived. I was so full of sepsis and infection that I should not have survived. I was out of work for 8 months. And so I went from being what I thought was invincible and never going to be sick and never going to die to almost dying. And after I got through that, I was introduced to elder law. And when I switched over to elder law, I decided I didn't want to do litigation anymore, but apparently I was very good at it, because everybody that I knew, all the attorneys that I knew, sent me all of the contested probate and guardianship cases that happen in these courts. And so I dealt with family fights over exactly what we're going to talk about today. And I say this over and over, and I tell my clients this: the only people that win when a family fights is the attorneys, because we're going to get paid no matter what. So one of the things I want you to get out of this class today is not only what you need to do if you're dealing with it, or if you think you're going to be dealing with this soon because of a loved one being sick, but also what can you do to help your family in preventing a lot of these issues that we're going to talk about. So let's dive in. What is administration? When you look at the generic term of administration, it's collecting, managing, and distributing an estate. So when somebody passes away, the administration of the estate is collecting the assets and collecting the debts, managing those assets, make sure they're controlled, and they get distributed to who they're supposed to get distributed to. So it sounds very simple, but as I put on the screen, it means a lot more than that. So Marty, next one. So what does it really consist of? I've broken this down into really different areas, different what I call categories. The first category is immediately post-death. Right after the person passes away, what are some of the things that we need to take care of? And these are the things that we often don't think about until it all happens, and then we're panicked and we're grief-stricken and everything else trying to manage what all this is. But if you know this ahead of time, if the person has put this in writing or done things ahead of time, you'll know whether there's organ transplantation issues, whether we need to deal with that, what do we need to do about transporting the body, and where does the body go? We need to locate families, friends, acquaintances, everybody that is close to this person so that they know about it. What about the primary care doctor? Quite often you've got to notify them because that's the person who needs to pronounce death. You have to arrange care for any dependents if we have minor children or if we have pets, and we have to secure the person's home. I had a case one time where I used to practice in El Paso, where I was doing a guardianship for a 102-year-old lady who passed away. The family didn't live in El Paso. They all lived in Mississippi. And they called me in a panic because she had just passed away and they were afraid somebody was going to get into her house and take things. So I said, well, if you give me authorization, I'll go up there. I'll change the locks to the house so we can secure the house. So I did. I'm up there changing the locks with the locksmith when all of a sudden 3 police cars come screaming up the street into the driveway. And unfortunately, apparently somebody thought we were breaking into the house. So at least they had good neighbors to call it in. So I walk out of the front of the house. I see the first police officer. Luckily, I recognized him because I used to work with him. And he looks at me and the first words out of his mouth were, "You don't look like a burglar." I'm like, "You're not right, I don't." But all of that happened because we hadn't planned ahead and we were panicking and trying to get this all taken care of at the last minute without notifying the proper authorities. Next slide. So after immediate post-death, then we look at pre-funeral. What kind of things need to be done before the funeral? We need to locate the final expense insurance if there is any. Is there a pre-need plan? Locate important papers, birth certificates, military papers, marriage certificates, Social Security. There's a lot of different papers. File insurance claim if you need to get that money to pay this. And for veterans, there's a lot of inquiry that needs to be done about special veterans. And these are the kind of things that we all know. And I'm not telling anybody anything new, but when that time comes, it's amazing how you're like, well, was he a veteran? Was he not a veteran? Does he have rights to it? Where's the paperwork? Because we as humans, and Americans especially, we procrastinate on everything that we do and we are not organized. So one of the things I hope you take from this is how important it is and how much love you show your family if you get organized. Next slide. So after the pre-funeral, now we look at the funeral. One of the things that we often don't think about is, oh, we got to write an obituary. Somebody's got to write it. Somebody's got to give the final words at the funeral. What about a memorial service? Do they want a memorial service? Do they want an actual funeral? Do we want a viewing? What exactly do they want? Quite often, the families don't know what the person that passed away really wanted because they didn't tell them. And so some of the most organized clients I've had even write their own obituary. And I know that sounds kind of morbid to some people, but think about how much pressure that takes off of a family if that's already written ahead of time and they have something to go by. Now, yeah, they can add to it if they want to, but at least they have something to know, oh, Dad wanted us to cover when he was in Vietnam and to share the fact that he served his country, things like that. Obtaining death certificates, that quite often is a problem because after the funeral, it takes a while to get them in. And you have to wait time, and there's a lot of stuff we can't do until those death certificates come in. And then finding a will. What did this person pass away with a will? Did they have a trust? Did they have any type of estate planning documents in place? And if so, who's in charge? And what do those documents say? Next slide. So after a person passed away, after we've dealt with the funeral, now we've tried to locate a will or not. Now we have to decide about probate. Probate is a fancy legal term that most people have heard the term, but a lot of people don't really completely understand it. But probate is nothing more than a legal process that a family has to go through when somebody passes away. So next slide. It is a judicial legal process that a person's estate goes through whether they die with or without a will. Now, I had a question in the chat before we were starting about, is this different in other states? You know, the person was from North Carolina. And yes, I want to clarify that probate is state to state to state. So every state has different probate laws and estate planning laws dealing with the documents involved. So it is very, very important that you have your legal documents, your estate plan in place for the state of residence, where you reside. And that's a big deal here in the DFW area because we have so many people moving here from out of state. And I get calls daily saying, I just moved here from California, I just moved here from Colorado, I just moved here from New York. Do my documents that I did there work in Texas? And I'd say, no, we have to look at updating them because every state is different. Next slide, please. So the need for probate. So a lot of times I'll get the question, well, does this person's estate need to be probated? Is there a reason for it? Well, it is determined again by state law, and the laws of Texas determine what types of property have to be probated. If we look at a person's assets, and quite often the first conversations I have with a family after somebody passes away is, okay, did they have a will? Did they have a trust? And what property did they own? And in what names is it? Because that determines a probate. Now, the biggest probate asset that causes probate 99.9% of the time is real estate. Almost all real estate has to go through the probate process. Now, there are other things that pass outside of probate, like IRAs and 401ks that may have a proper beneficiary designation, or checking accounts that might be joint with somebody, or transfer on death, TOD, pay on death, POD. So there is property that does not need to be probated, but that's the important part, is determining what property did this person own, and does it require the legal process of probate. Next slide. So another part of the process of probate is these two steps. We have to authenticate that the person's dead. And I know that sounds kind of funny, but one of the questions that the court asks is, show me proof that this person has passed away. And why? Because of fraud. We don't want somebody faking their death, or a family pretending somebody's dead when they maybe disappeared. We have to prove the death before we can do number two, administering the estate. What did this person leave behind? And where does it need to go? Next slide. So as I said a little bit earlier, probate is almost always required if these things occur. Real estate, number one, but also any accounts that is in the person's sole name. So if mom has a checking account and she's the only one on the account, then that account will have to be probated. Now, I get this all the time. Well, I'm on mom's account, so it should be fine. Well, you need to talk to the bank and see what that means by being on mom's account, because it can be a joint account, but it also can be a signer account. So it's mom's account, but I can sign on it. Well, if I can only sign on it, that doesn't give me authorization to receive it when mom passes away. So you need to make sure that the accounts, the investment accounts, the retirement accounts, the banking, checking and savings accounts are all titled properly so that they pass outside of probate. And if accounts that the property not listed by beneficiaries, I get that all the time. Mom had an investment account and she didn't list a beneficiary. Or I've even had some people that were told by their financial advisor to list the estate as a beneficiary. Well, that causes probate. So that can be a big problem. Another big problem that can cause multiple probates is owning property outside of the state. So if I have a lake house in Oklahoma and I have a beach house down in Destin, those things all need to be probated in the state they're located in. So quite often we have to do multiple probates to be able to transfer real estate. Next slide. So there's some, I kind of inserted this one here because this is one of the biggest misconceptions I have about a power of attorney. The one thing you need to realize about certain documents that we call estate planning documents, and that's your powers of attorney, your healthcare directives, your HIPAA forms, is that certain documents are living documents and certain documents are death documents. And I get this question all the time. I have dad's power of attorney. Dad passed away. Can I get into his bank account and pay his bills with this power of attorney? No. The power of attorney dies when the person dies, and it is no longer any good. It does not survive death. So you trying to use a power of attorney after death can cause criminal problems called fraud if you do use it. So that I just wanted to bring that up so that people don't have that misconception that, well, if dad has a power of attorney, if mom has a power of attorney, we are okay. We can administer her estate with that. You can't. Next slide. So then we look at the death document. The most common death document is the last will and testament. Next slide. The one thing to remember about a last will and testament is that if you don't have one, you do have one. It was just written by the state of Texas. So if you want to trust the government with your estate and your family and your distribution of your assets, then you don't need to do a will, but I have not met that person yet. Most of us know better than to trust the government with our family affairs. So at minimum, you need to do a will so that you get your wishes done, not the government's wish. This can cause a nightmare if you die without a will, depending on the family structures, especially in a blended family where we have children from a first marriage and now we're in a second marriage, and maybe we have children from the second marriage. If a person passes without a will, it can cause major problems with the distribution because the things won't go where they're supposed to go. So by having a will, you decide who gets your stuff. You decide who you name as the executor, who is the person in charge of distributing your stuff. You get to assign guardians to minor children, but I don't recommend doing this in a will because it can cause other problems. And the judge always gets the final say. You can outline funeral arrangements. And again, I don't recommend this because it takes a while for the will to get to court, and the funeral is going to take place before the will is even probated. So we always want to do funeral arrangements outside of the will. You can do what's called a testamentary trust. A testamentary trust is a trust written inside of a will that says, when I die, I want this trust to go into place. Now, personally, I'm not a fan of testamentary trusts because a testamentary trust doesn't give you any benefit during your life, and it puts the burden on somebody else to set it up after you die. So if you want a trust, or if you need a trust, we recommend people consider living trusts, which is a trust you put into place while you're alive. It also, again, it's triggered upon death. This is one of the things that is a big misconception about the will. Everybody thinks, okay, the person dies, the will goes into effect. I even get people that say, well, the person had a will, so we don't need to probate it. No, the will just says what needs to be done, and death only triggers the will. The probate court has to authenticate and accept the will. That can be months. So we can have a person pass away in December, we can file the paperwork in January, and we may not get to court till February or March. So in that lag time, we can have a lot of problems. Things won't get paid. Things aren't being done. Children, minor children that have a guardian listed in the will may not be with that guardian during those months, because I've had cases where Child Protective Services came in and said, we're going to take custody of the minor children until the courts decide who the guardian's going to be. So that can cause major problems. So a will is something that everybody should have at minimum, but it's not the best way to do things. So if you're thinking about doing a plan yourself, you need to talk to somebody about the other options that are available. Next slide. So if you have no death document, as I said earlier, if you don't have a death document, you don't have a will or trust, then it's called an heirship with administration. That means that it still has to go to court. The judge decides how everything goes. Texas law decides how everything goes. And we have to determine who the heirs are, who gets to accept property on behalf of this person that passed away without a will. Next slide. So this again is the legal process of who inherits, and somebody who fails to leave a valid will, this is the plan that goes. Now, one of the nightmares, as I kind of led to earlier, is a blended family. I had a case one time where a lady came into my office. She had been married to her husband for 18 years. They owned a house together, paid in full, and he suddenly died, rather young. I'm asking her questions, and one of the questions I asked is, do you have children? And she said, no, we didn't have children together, but he has a daughter from his first marriage who's 19, who's a real blank. So apparently she did not like her very well. They did not talk to each other at all. And I said, did he have a will? And she says, no, he didn't have a will. He wanted me to help him do one, but we didn't have time to do that. So I said, well, ma'am, I'm sorry you did that, because by him passing away without a will and him having a daughter outside of the marriage, his half of the community property, meaning his half of the house, goes to his daughter, not to you. I said, his daughter just inherited half of your house. And she says, you mean my daughter just inherited $125,000 in equity? And I said, no, ma'am, she inherited ownership. You are now partners in that house, 50-50 with your daughter, your stepdaughter, who you hate. She was livid. And that's what I mean. Things can happen. I don't think the man that passed away would have wanted that half of the house to go to his daughter. I think he would have wanted his wife to have it because they bought it together. But it didn't go that way, and she was in a big mess because of it. So airships are necessary, but they're big, big problems, and they're a lot more expensive in legal fees. Next slide. So why should you avoid probate? It can get very expensive. Again, you have to hire an attorney. We have what I call job security laws in Texas saying you cannot do a probate on your own. You have to hire us. Isn't that nice? So we get our legal fees. And your typical cost of a probate with no problems is about $4,500 to $5,000 at today's rate. And you know it's not going to go down. It'll continue going up because we have court costs, we have publication costs, we have maybe executor fees, attorney's fees, accounting fees. It's a time consuming, but the worst part is it's a public proceeding, meaning everything that goes on in that proceeding is public record for the entire world to read. So when a person passes away and I file a will for probate, that will becomes public record for anybody to read it. Then after the proceeding, we have to do what's called an inventory. I have to do a list of all the assets the person had when they passed. That inventory becomes public record for everybody to read. Who reads it? Bad people, predators and creditors. So I tell my clients, you're going to get preyed upon, you're going to get scammed, you're going to get junk mail, so get ready. And if anybody calls and says things to you, talk to me before you do anything. Because I've had clients call and say, I got a letter that says if I don't send them $2,000, they're going to put a lien on my house. It's a scam. So that happens all the time. So the worst part about probate is the public access to all of the things that go on. Next slide. So how do we avoid that, or how can somebody avoid that? I mentioned earlier a living trust. A living trust, in my opinion, is one of the best things ever invented, because it allows a family to do two big things. Keeps the courts out of their life and keeps the family out of their life. So if you have a loved one that's just passed away and they have a trust, your life is going to be a lot easier to get through it than it is if they don't have a will, or even if they do have a will and you have to go through the probate process. A living trust is an absolute necessity for most families, and it's not just for the rich, because a trust is not a trust is not a trust. We design, in our office, we design trusts for the families we're designing them for. And so a family that's worth $500,000 isn't going to do the same thing as a family worth $500 million. So we set them up according to the families themselves. So you need to talk to a professional that does this for a living if you're interested in looking at something like that for your family, for your parents. I get people call me all the time, hey, my parents are elderly. Can we look at setting a trust up for them so that our life is easier when they pass? Yes, we can do stuff like that. So let's move on to the next slide. So if they have a trust, if a person that passes away has a trust, instead of having to go through the probate process, a trustee, who is the person appointed to manage the assets and take care of it, does it in the privacy of a law firm office. So you usually go to the attorney that did it, or some attorneys don't do trust administration. So you go to an attorney that does trust administration, and that attorney will walk you through the process, and everything is done in private. Nothing is filed with the courts. Nothing is filed at public record. It is all done in the privacy of your family. Next slide. So even with the will and the trust and everything else, and we have to go through administration, I want to go through a few things that a lot of people don't think about beyond that, because I'll get people that'll call me all the time and say, okay, I know you can help us through the probate process or whatever, but I wanted to put a list together of all these other things that we don't even think about, like utility companies and post offices and post office box, and trying to identify the financial institutions and the insurance companies, mortgage companies, auto loans, credit cards, employers, employees, employers, past employers. Did they have a benefit with somebody they used to work with? So if this stuff isn't organized, it makes a family's life very, very difficult beyond administration of the estate in the legal sense. I made the mistake one time of, I never will be a trustee or an executor for my clients. It's a conflict of interest. If I'm doing their plan, I don't feel comfortable being the administrator of the estate. But I had one gentleman who was a very good friend of my family. I'd known him for years. His wife had passed away. He wanted me to redo his plan, and he begged me to be the executor, because he said, if you're not the executor, my family will fight over everything. If you are, everything will go smooth. And I said, okay, I'll do it. It was a nightmare, because it took me 3, almost 4 years to administer his estate, because he was so disorganized. I didn't know what he had and what he didn't have. And I had to hire financial professionals and CPAs to track down stocks and bonds and all kinds of stuff that he had. He had stock from Enron. For those of you old enough to remember the Enron fiasco, he had stock from them, and it wasn't worth a penny, but I had to take care of it. I had to distribute it. I had to do all the things with it. So it was a lot of work. And that's what happens with families when there's not organization, and the person doesn't leave lists of, okay, these are the government agencies you need to contact. These are the people that I want to contact. Next slide. So ultimately, it all comes down to gathering, paying, and distributing. Gathering everything, and that includes, okay, who's the utility company, who's the financial institutions, who's the mortgage company, gathering all of the assets, finding these stocks, finding these bonds, finding these counts out there. And there's no way, there's not like one central repository where you can call and say, okay, what all did Mr. Smith have? Sometimes it requires a lot of in-depth research. I even have to gather heirs. So sometimes we have to figure out who the heirs are. And there are companies out there that you can hire that will track down, okay, who's the second cousin, who's the third cousin, because I've had to track down multiple layers of heirs for some of my cases. I had a case one time where we had a house involved, where when it was all said and done, there were 22 heirs to this house. So every one of them got 1/22 of this house, so it was worth about $60,000. It wasn't worth the headache of going through probate for that. And I think they ended up walking away from that house and letting it go back for taxes, which is sad, all because the person wasn't organized. So you have to gather assets and debts and everything else. You got to pay the debts. So we got to look at debts. One of the things I want to remind everybody, though, is that the law says who gets paid and who doesn't. So when somebody passes away, don't automatically pay debts until you talk to an attorney. I always advise my clients only pay 2 types of debts: ones that'll be turned off, like utilities, and ones that'll be taken away, like house and car. So other than that, we don't pay anything until we go through the legal process. We don't pay medical bills. We don't pay debt, credit cards. We don't pay loans until we go through the legal process. And then when it's all said and done, what do we have left, and who does it get to go to? Next slide. So I've kind of gone a fast forward way through this. The attachment that we're handing out to you goes through a more in-depth, like 42 point checklist. I've tried to be as detailed as possible so that we don't forget anything when you're going through this process. But yeah, let's go ahead and turn it back over to Marty. And do we have questions that we want to address?
Yeah, there are a few. But when you're doing that, I'm going to stop sharing here, and I'm going to share the document.
Okay.
The other document, if I could. And
okay.
and then we can walk through that real quick. Let me see if I can grab that here. I had to make some changes to it, but this is it right here. Sure. Let me move it on here now. Are you seeing that document now or not?
I am now, yes.
Okay, great. So here's the document that has the checklist. Fred, go right ahead. You speak to it if you would.
Yeah, I just kind of put a real brief definition of administration and probate at the beginning, and then the assets that are most likely going to cause a probate. As I said earlier in the thing, a real estate and out-of-state real estate. But there are some other items that I've listed on there that will cause probate. The last one on that list are assets out of a trust. And this is a thing that bothers me all the time when I have clients that put together a trust, but they didn't align their assets with the trust. And so those of you all that are familiar with the trust or thinking about a trust, or your family has a trust, one of the most important things about a trust is like a treasure chest. You build a treasure chest and you have to put your treasure in it. And if the treasure's not in it, then it's not covered by it. So for instance, the first thing we do for people when we set up a trust is we deed their house into the trust. So instead of Mr. and Mrs. Smith owning the house as individuals, the Smith Trust owns the house, and Mr. and Smith are the trustees of that. That avoids probate. So it's very, very important that you talk to somebody that does this, so that they know, how do I align my assets with the trust so that nothing's left out, because if something's left out of the treasure chest, it may have to go through probate. And then I've put together what does a estate consist of? Administering the estate consists of arranging, locating, and then I think the next page, Mario, can you scroll it down?
Yeah. Are you seeing that?
I'm seeing the first page.
It didn't scroll. Okay, let me go back up and see if I could. If I do it that way, did it show the second page?
Let me see. I'm still seeing the first page myself.
Okay. Let me stop sharing and see if I can reshare it on the second page. Let me just try again. Sorry. Now does that show the second page?
There it is. There we go.
Great.
And so that's 6 through 28. This is that 42-point checklist that goes down for this page and one more page. And I've just kind of outlined as much as we can think about that we found people deal with that they don't think about. One of the ones, like number 7, a lot of people just don't think about pets. When somebody passes away and they have a dog or a cat or even something else, like I had a family that I had to set up a trust for because they had turtles, and they wanted to make sure they set aside money so that those turtles went somewhere and were taken care of after they passed. We need to make sure of that. Insurance claims, veteran issues. I've kind of gone through a lot of what I did in the presentation. Number 20 is identifying and notifying the companies, like mortgage companies, utility companies, credit card companies. Sometimes that can be very hectic, and sometimes that can take weeks, if not months, because you're waiting for bills to come in. And when somebody has things on auto pay, they may not get bills. So if you don't have access to their computer accounts, that's one of the things I put in this list, is access to passwords and who all do they have login. I have a whole sheet. It's kind of funny. My wife doesn't know anything about anything that we do because she doesn't want to, but my daughters do. My daughters know exactly what our passwords are, exactly where my list is of all our online accounts. So if anything happens, as long as my 2 daughters are around, they'll be able to get to it and be able to take care of all of it. But you need something like that and someone to know where all of it is. Can you go to the last page? Okay,
I'm going to go down here, and then I may have to do that.
That one did scroll. Yes.
Okay, great.
Okay. So I was wrong. I thought it was 42. I must have added one somewhere because I see I've got 43 on there. But we all go down to the paying the creditors, inventorying the assets. Sometimes in inventorying the assets, we have to hire people to do actual assessments and value things, especially if the person passed away with collectibles like coins or guns or artwork or antiques. You have to actually hire an appraiser to give a formal value of those. That's, again, where it gets more and more expensive. The last thing I've put on this list is some contact information for some various departments that you might need to reach out to. I've had to call these numerous times to see, okay, do you have anything on Mr. Smith in your Veterans Affairs record? Did he serve? If so, when did he serve? Is he entitled to a military funeral, etc.? So hopefully those will help you. I've even put in credit bureau reports, because sometimes that is very helpful to be able to reach out to the credit bureaus. If you provide them with a death certificate, and especially if you're going through probate, and provide them with the documentation from court, they have to give you what's in their records for that person so that you can track down some creditors and stuff like that.
And make sure that everybody sees that your contact information is at the bottom here. I have to take off logos and that kind of thing on materials like this just because we're paid by the state to put these on. But I want you to know their contact information for Haiman+Hogue is here at the bottom, and the phone numbers, email addresses, it's all on there. Somebody asked if they can hand out this form to people that they work with, their clients, and
that's, you can do whatever you want with it.
Well,
that's what I put it together for.
And I will suggest to you, I've modified the bottom of it just because I have to for this presentation. If you want the original one, which is it's the same thing, it just looks a little bit different. It has their logo on it. You can email Sheila for that, and she can send that to you if you'd like to have that.
I will be happy to.
Yeah, that one. So I just can't send that out on my end. So there were a few questions. One,
Well, there's
somebody
24 questions here. There's 26 questions.
Yeah, somebody was asking about if the family's responsible for hospital bills or expenses of the deceased person.
Thank you very much for that question, because that's a very important question. No, the family is not responsible for the debts of the deceased person. Now, one of the things that we even need to I need to emphasize, in Texas, everybody knows that Texas is a community property state, but it is not a community debt state, meaning that if my wife has a credit card debt and it's in her name only and she passes away, I'm not responsible for it. Only her estate is responsible for it. So that's why I always tell people, don't pay debts until you talk to a legal, get some legal advice, because there's a lot of the debts that don't get paid. And they don't get paid because there's a pecking order of who gets paid. Who gets paid first? Number one, funeral expenses. Number two, and you can tell who wrote the law, legal expenses. And then it goes down from there. Credit cards and medical expenses are like 8, 9, 10 on the list. And so when you look at paying debts, the family is not responsible for them. We look at the assets to the estate, and we don't have to sell assets in order to pay debt. So for instance, if all they have is a house, but they don't have any cash, then they can't force us to sell the house to pay the medical bills. So that's why it is so important you get legal advice when that time comes.
Great. Kathy asks, her dad passed away 4 years ago. How long should she keep it, the DD-214?
I would keep it for the rest of your life. I mean, I don't think, usually within 4 years of a person passing is when you need to probate the estate, and there's certain things that need to be done. But there may be a time that comes up later in your life where, your father was military, and I would just keep it. Keep that handy. I wouldn't destroy the DD-214.
Okay, Fred, if by the time someone dies and we no longer have a need to probate the will because things have otherwise been taken care of prior to death, can the person named as executor in the will still assume that role without probate? The executor would still need to deal with all the little details.
Okay, technically no, because the executor named in the will, think of the will as a wish list. So I'm saying this is what I want to happen, but the court has to bless off on it. So an executor doesn't become an executor, a legal executor, until he's granted that authority by the court. Now, does that not mean that that person can distribute things outside of probate with everybody in cooperation? Sure. Yeah. I mean, if a family's getting along and they are all in agreement that oldest brother's going to take the role of distributing the furniture and, you know, doing the things we need to, and we don't have to go through the court, sure, they can do that, but they don't have technically legal authority without the court's blessing.
Okay, is a probate required if their estate is in trust for someone?
No. So if the trust, if you have a properly drafted trust and the assets are aligned with the trust, then no probate is needed. That's the greatest thing about it.
Okay, does the appointed executor take over administration immediately, or do they have to wait for probate?
They legally have to wait for probate. Now, they usually will do, like when I have an executor contact our office and hire us to file the probate, we'll have the executor do what they can before we get to court, because there's certain things that can be done, but there's a lot that can't. So like if the executor says, well, I want to contact Fidelity. No, Fidelity's not going to talk to you without getting a piece of paper from the court saying you have authority to talk to them.
Okay. What if there is a blended family and there are previous wills prior to the marriage? Problem?
The last will wins. So if there is a valid will that was done most recent, that's the one that wins. So it doesn't matter how many times you've done a will before. The question comes in, and I get these with blended families, and that's when family fights start, is this last will valid? Did dad have the mental capacity that he needed to do the will? Was he under undue influence when he did the will? So a lot of that becomes issues. And I have had fights where we've gotten the last will thrown out because it wasn't good, and we went with a prior will. So in situations like that, you definitely need legal counsel.
So if I have a living trust, then when I die, the case does not go to probate.
If it's properly, if the assets are properly aligned to it, yes.
Can you create a spreadsheet with all of your assets and debts and put it in important papers into a security box at home?
I highly recommend that, as long as somebody has a key to that security box. One of the things that we have problems with is people will get a safe deposit box, and they won't give access to other people in the family. And so if a person passes away and there's not another legal authority, the bank won't let anybody else get into it without a court order. So I've had to get court orders to open up safe deposit boxes to get wills, for instance.
Okay. I am single, live alone, and have no family or friends that I can trust. Who could I use as a substitute trustee for my revocable living trust?
Yeah, that becomes difficult when you don't have family or friends. I'm doing one right now who has asked people at our church to be named for her healthcare directives and stuff like that. But there are professionals we can name. There are professional trust companies, and then there are also professional fiduciaries that will be appointed. The problem, of course, with them is they're going to charge. They do it for a living, so it costs money.
Okay.
Sometimes you can get your CPA or your financial advisor's office to do some of that.
Do you have to go through probate if there's only one home and it's valued at $80,000 to $90,000?
Yes, it doesn't matter the value of the home. It matters in how the home is titled. So if the home can be a $20,000 shack, and it can be titled in the name of the person that passed away, it's got to go through probate.
Okay. In what circumstances would a trust be probated? For example, an executor that refuses to give accounting, etc.
Okay, there's a big misconception between what an executor is when you have a trust. An executor has authority under a will. A trustee has authority under a trust. So if you have a trust that the trustee is not giving an accounting, then there can be litigation brought against the trust. That is very uncommon, but it can happen. Most times trusts end up in court because they're not all properly funded. The assets are not all in the trust. But I have had a few unfortunate trust contests where the trustee wasn't doing their job, or the trustee wasn't being honest, and other family members had to hold them accountable.
Okay. Would personal property such as clothing and a TV trigger probate?
No, not usually, unless there's family fighting over it.
Okay. Are there any organizations or groups who could administer an estate for a fee? I don't trust anyone in my family or friends to do any of it.
Yes, so there are professionals we can appoint that can take on those duties.
Okay. If someone was married and had one child, 3 cars, and no other assets, including no savings, would they need probate?
Probably
that-
not.
no.
Probably not, because cars pass outside of probate very easily. There's laws under the Texas Transportation Code that will allow you to transfer a car without probate.
Okay. And we'll be able to get a recording of this presentation? Yes, because Marty sends it out.
Yes, it will go out in about 4 or 5 days to everyone who is registered.
Does everyone need to supply a death certificate to the credit bureaus? Is that a requirement?
Not a requirement, but a very good idea. You want the credit bureaus to know about it so that there's not identity theft issues, because that's a big problem. Also, if there's anybody else in the family with the same name or similar names, when my father passed away, I had issues with my father's credit going on mine, and we notified him with the death certificate so that they knew to freeze his and stop his account. So it's a good idea, but I don't know of any law that requires it.
Okay. Oh, what is Sheila's email address?
I actually put it in one. I'll answer it again here. I put it. It's in the chat, just so you know. I put it in the chat very recently. I'll put it here too.
Okay. Is a handwritten, signed, and dated will legal in Texas?
Yes, it is. It's called a holographic will. It's not advised, but yes, it can be considered legal.
Okay. We get this one all the time. How do I bring up this topic with my parents to find out what they have set up, if anything?
That's a difficult answer. It's a lot of it deals with family dynamics, but after you watch this presentation, this is a perfect opportunity, because you can go to them and say, hey, Mom, Dad, I just watched this presentation and it really made me get to thinking. And I know we don't want to like to talk about this, but it's a great conversation starter. And even you can show them this presentation. So I've had people do that, where they'll bring this presentation, say, Mom, Dad, will you please watch this, because this is something we need to talk about that would make life so much easier for us if we know what's going on.
I want to add that we actually did a webinar just on this topic in December, and if you'll email me, I'll send you the link to that as well. And this and that together, and then the trust seminar that Fred did for us a couple of months ago. I think the 3 of those could really get you a long way in where you're trying to go.
Yes.
Awesome.
And when do I need to create a will?
Now, yesterday. I mean, there's no time too soon. Everybody over the age of 18 needs one. So I actually do plans for 18-year-old kids, and people think, why would you do an 18-year-old kid? They don't have anything. Well, we don't know what they're going to have when they die. I had a case in Texas where a girl was broke during life. She was working minimum wage jobs just to feed her kids, and she dies in a tragic accident, and she's worth $2 million in death. So she was worth more in death than she was in life. And because she didn't have a will, the fight is on, and 1.4 million out of that 2 million went to legal fees. So everybody needs a will, at least.
And you got to have it before you die, and you could die anytime. So now.
Yeah, it's kind of hard to do it after you die.
Yes. All right. This is, okay. There's 3 questions here, but they all seem to go together. What or who triggers probate? Should direct kinship, which it says spouse and or children, expect to receive documents from the government?
Okay, I'm not really sure. I think I understand what you're asking. Anybody that is a heir or a beneficiary to the estate can initiate probate. So triggering probate is death. When somebody passes away, that triggers a possible probate issue. Then we look at, does the estate need to be probated, and anybody with interest in it can initiate it. So it doesn't have to be the executor, but usually it is. And then expecting papers from the government, there's really not papers you get from the government other than the death certificate. All of the other papers are papers that were done by the person that passed away. And a will doesn't have to be filed before death. So if a person has a will, it's not like it's at the county of record. It can be in a drawer somewhere. So there's not any requirement that says you have to file these documents ahead of time. So I always tell people, when you do your documents, make sure the people in your life that you love and trust know you have them and know where they are, because they're going to need to find them when that time comes.
What about insolvent estates?
It depends on the issue with the insolvent estate. An insolvent estate, we pretty much know the creditors aren't going to get paid, but sometimes even in an insolvent estate, it still has assets. So if I have an estate that has a house and 2 cars, then those are assets that have to be distributed, but it's insolvent because there's no cash money to pay debts. So it still has to be probated, and the creditors still need to be notified, and they're notified that the estate's insolvent. And so they know, well, we're not going to get paid. Oh, well.
Can I ask you a question about that? Now, the administrator is entitled to get paid for their time. Is that not correct? Is that on the priority list, just like the legal fees, where just because you know you're not going to get any money in the end, but you are going to get paid for the work it takes to get this taken care of, right?
Yeah. I think the administrator's like 3 on the list. They're right after legal fees. They get paid. Yes.
Nice.
All right. How often should wills or trusts be updated?
Very good question. We recommend that our clients come talk to us and look at it every 3 to 5 years. By 5 years, there's been so many changes that you need to probably update it. I had a lady I talked to yesterday. I did her will in I did her trust in 2016. We averaged about 20 to 30 changes to our legal documents every year. Those are legal changes. Those are legal strategy changes. Those are updates. Those are changes that we, just doing better, kind of like a car gets better safety equipment. So after 5 years, you're looking at 100 to 150 changes on our side. That's not counting if your life has changed and your finances and changed. So 3 to 5 years is a great point of reference. I don't like when my clients go for more than 5 years, because then we completely have to redo a lot of stuff.
Okay. If our only asset is a home outlined to be equally divided in the will, and we have a ladybird deed, pre-death granting 4 beneficiaries, do we have to go through probate?
Okay. If the ladybird deed is properly done, and I have to clarify that because I've seen too many ladybird deeds that were not done properly, even by attorneys. So, but if the ladybird deed is properly done, then that house passes outside of probate, because what a ladybird deed says is that the person owns the house today in what's called a life estate. So it's my house while I'm alive. I get to use it. I can sell it even if I can do whatever I want while I'm alive. But the day I die, it goes to who I say it goes to. And so if the ladybird deed says it goes to 4 beneficiaries, that house will pass to those 4 beneficiaries, and there will not be a need for probate if it's properly done.
Okay. What is important about canceling driver's license, prescriptions, etc.?
Identity theft. That's really what it comes on down to. There is so much identity theft by using dead people's information.
Okay. I have a revocable living trust, but I cannot put my IRA into the trust. Why is this? Can I designate?
IRAs have
okay, sorry. There's more.
Okay.
Can I designate my
go ahead.
trust? Okay, go ahead.
Go ahead, because I think you're going to answer some of my question.
Okay, can I designate my trust at the beneficiary? Okay, no, back up. Can I designate my trust as the beneficiary of my IRA in a POD or TOD?
Okay. You do not want a trust to own a retirement account because there are laws that give ultimate protection of retirement accounts while you own them. So in essence, it has more protections outside of the trust than inside the trust. So I own my IRA in my name, but when I die, the first person I want to get it is a spouse, because spouses get same protection as I do. So if you're married, you want to name your spouse as number one. If you're not married, you name the trust as number one. If you're married, you name spouse as number one and the trust as number two. So yes, you do want to name the trust as a beneficiary of the retirement account, either the primary beneficiary or a secondary beneficiary.
Okay.
So in essence, one of the things to think about a trust, the trust either owns the asset or it catches the asset at some point.
Okay. What is a reasonable amount of time to notify people of the death? People like credit card companies, Social Security, et cetera.
I mean, there's no set time. I would just say, you know, when you start the legal process, we start notifying them. So sometimes it can be within 6 months of death. The law says that you can take up to 4 years to probate a will. So even if you know, there's nothing that says if a person dies today and I don't probate the will for 2 years that I have to notify creditors before that. You don't, but it'll cause problems. So I always just say the sooner the better.
All right. What if your parents that are in their 80s live in Missouri and have a house they still pay on and property, but nothing really planned for their future death?
Okay, they need documents from Missouri, so they need something up there. If they don't have documents in Missouri and they passed away, then the probate would have to take place in Missouri under Missouri laws.
Is tax deductibility, such as property taxes, impacted by being put in a trust, housing, and other assets?
Not if it's done properly. So we have a revocable living trust that has a house in it, doesn't affect tax exemption, doesn't have homestead exemption or over 65 exemption or disability, doesn't affect it at all. But it all depends on how the trust is drafted, because like I said earlier, a trust is not a trust is not a trust. And so it has to be properly drafted. And that's another reason why we have problems with people that come from other states, because for instance, a California trust is not properly drafted for Texas to give us homestead and tax exemption protections. So if you put your Texas house into your California trust, you can have problems. So it has to be drafted properly.
If I don't pay the credit card companies, will it affect my credit even if I'm not on the credit card, but I'm the spouse?
No. If your name's not on the credit card, it won't affect you at all.
Can I assume a loan that is in my spouse's name after his death?
It depends on whether the company that has the loan will let you do it. So yes, you technically can if they will allow you to do it, but it's under their rules. There's not a law that says they have to let a spouse assume a loan. You have to talk to them and try to convert it over.
Okay, this is a really good one. Can you speak to the Medicaid estate recovery for use of caregivers? Many families pass on the Medicaid benefit because they're afraid their home will be taken after they die.
Okay. Yeah, that MERP, Medicaid Estate Recovery Program, their job is to go after Medicaid repayment after a person dies. So if somebody is on Medicaid and they pass away, this program needs to try to recoup some of the money that the government paid. And one of the ways they can recoup is by putting a lien on a piece of real estate. So there are ways around that. And one of them we've talked about already. Somebody mentioned a ladybird deed. So a ladybird deed is a way to get away from the estate recovery program because they can only attach to property after the person passes away. And if the house transfers immediately upon death to another person, they can't attach to it. So there are ways around it. And so one thing you just need to tell your clients is don't avoid Medicaid for that fear. We can get around it. You just need to talk to somebody like a Medicaid professional that knows how to do it. We have an attorney and a paralegal in our office, and that's all they do. I don't do it because it's so complicated that I can't dabble in it. We have professionals in our office, and that's all they do. But I know when I talk to them, they're like, we can get around that. We can get around that. We can get around that. And usually, I always say it's Caesar makes the rules, and we use Caesar rules to our client's advantage. And a lot of those rules say that they can avoid Medicaid recovery.
Okay. Can you put your name or like Sheila or Jeff with the name of the person you want to have your home, or do you need to do something different on the mortgage?
Okay, there's a difference between the mortgage and the deed. The mortgage is a loan and the deed is the ownership. And so I think what your question is on the deed, who owns this? It all depends on how it's written. And so writing a deed saying Mr. Smith or Mrs. Smith, that really doesn't go well. There are ways to do deeds properly, like transfer on death deeds. I'm not crazy about them. I don't use them much because we don't know how the title companies will view them years down the road. But you need to talk to a person that does real estate deeds to do that properly.
Should I assume all of my dad's assets will be going to his wife?
No. I mean, you know what happens when you assume. I would never assume anything. So I just say, you need to talk to dad.
Okay. Actually, should you put the person you want to have control of all of your bank accounts, home, car, etc., as my name or person you want to have control?
I'm not sure I completely
I don't understand that
question. Joint accounts are not a bad idea in certain circumstances. There are times we don't recommend joint accounts. So like I have an account with my mom. I take care of my 89-year-old mom. So I live what I do for a living. And I have a joint account with her because she doesn't have much in it. And so my credit, my debt can't affect her that much, and hers can't affect mine because there's not a whole lot. But some accounts that have thousands of dollars, we don't recommend it because it can cause issues back and forth. So it's just, I would get some legal advice on that. And sometimes you can talk to financial advisors and they can advise better on that. I think we're getting really past time. I don't know how much longer we want to continue.
That's up to Marty.
Hold on. We still have a lot of people.
Yes, we're good.
We used to have 140 people.
Yeah.
To keep answering the question.
And there's quite a few questions left, Fred.
Yeah. So, I mean, they're obviously interested in listening. If you want to keep answering them.
Yes. Okay.
I'm good.
Okay.
Let's keep going.
Mom has one car. This is detailed, Fred. Mom has one car, and I now know that passes without probate. Do we need to put her cash in a trust instead of probating her existing will? 6 kids. She wants the money used for the son who is in assisted living. I'm the responsible child who will make sure he is cared for, but don't want other brothers trying to get a hold of leftover money. The will states everything goes to me.
Oh, that is, no, you don't want that. Yes, the answer is you definitely want to trust. One of the big problems that can happen in a situation like this is if all the money goes to you and then you use it to care for your brother, the law looks at it as you are getting it. It's all becomes yours. And now you're gifting it to him. And that can cause a major gift tax problem. So you don't want that. A trust can fix all of that problem. So a trust can be put in there that says, this is what the money's for. This is who it's for. This is who manages it. It fixes all the problems that you can have that you definitely want to fix what you've got right now.
Next, how much does it cost to have you prepare my estate planning documents?
I was waiting. It takes forever for that question. And I'm going to give the typical attorney answer first. It depends, because if you do it right, your price should be tailored on your family, because we don't do a one size fits all. There's no such thing as that in our office. Everything we do is tailored to our families. So I can tell you that we have plans that start at $750. I have my college student protection plan, and they go up to $15,000. So it really all depends on the family and what they want. We do a thing we call the Family and Money Protection Plan. And so it's a plan that says, I'm going to build you a house, and we're going to talk about what rooms need to be on that house. And if you want to add this room, this is how much it costs. If you don't want that room, then we don't add that room. So that's what you really want, somebody that'll do that for your family, that'll tailor make this plan exactly for you. They won't sell you any more than you have to have, but they'll give you all the options of what, do you need asset protection for your children? Do you need retirement plan protection because you have retirement money? So you got to answer all of those questions before you really get down on a price. And that's why we don't charge for initial consultations. I talk to clients all the time first, because I don't believe you should pay to figure out what you need to do. And then once you figure out what you need to do, then you can decide, okay, this is the options. And typically there's multiple options. So I can tell my clients, if you do this, it's out this much. If you do this, it's this much. If you do this, it's this much.
Okay. What should you expect to pay to an administrator that you're, like a third party?
I don't really know what their fees are, but typically they're based on a percentage of the estate. So I know that there's like trust companies that will charge 1% of whatever the value of the estate is. So if it's a $500,000 estate, that their fee, is going to be 1% of that. That's kind of what I find typically. It runs in a percentage range.
Okay. Does a legally prepared will bypass probate?
No, not in Texas.
Are legally named beneficiaries subject to probate proceedings?
If they're legally named in a will, yes, they are.
Okay.
The main thing to learn about a will in Texas is it does not avoid probate. It has to be probated to be carried out.
Does the court get involved to make sure that all the conditions and wishes of the deceased are met?
It depends. There are two types of probates. There's independent administration and there's dependent administration. Independent administration, the court does not get involved. Dependent administration, the court does get involved. Most of them are independent.
Okay. What is the cost on average for a revocable trust?
Again, it depends. Most of my trust packages for single people start around $3,500, and married, like I said, can go up to $13,000 depending on what all needs to be done. I would say your general ballpark range is from $3,500 to $6,500, typically, depending on what you need. And I know that's not cheap. To do it right, it's not inexpensive. But when you compare that to the fact that a probate is $5,000, if you do a $4,500 trust and avoid a $5,000 probate, sounds like you've made money. Not only did you make money, but now you've got protections you never would have. So that's what you kind of have to look at. Is what do you get for it?
We only own a house together and have filed a TOD. Why would I need a trust?
Okay, so you have only a house and then you have a transfer on death deed. That deed will transfer it between husband and wife. So it works fine if only one person dies. It doesn't work fine if you both are killed in a car wreck together. So that causes major problems on a TOD if both spouses pass away at the same time. A trust can fix that. So, and another thing is I mentioned earlier, I don't like TOD, transfer on death deeds. And even though the law, it's kind of, I tell people there's a difference between the law and the rules. And even though the law allows us to do them, the rules that title companies have are different. And I don't know how title companies are going to view these later. And a lot of people say, well, they have to view them. No, they don't. Title companies are insurance companies. They underwrite things. So for instance, you are allowed to do a quitclaim deed, but title companies will not recognize a quitclaim deed anymore. So I don't do quitclaim deeds at all anymore in Texas because title companies will not honor them. I think that that same problem is going to happen with TOD deeds in the future. That's my concern.
Okay. Sorry. Deceased parent medical bill in Texas and protection from bill collectors. When bill collectors contact adult children of the deceased parent, since they are not liable for the bill, are they in their legal right to send a letter to the collection agency asking them to not make contact?
Yes.
And that will not affect their credit report, right?
If your name's not on the bill, you're not responsible for it.
Okay. All right, there's a person that doesn't understand why there's Medicaid recovery. You want to try and explain that?
Yeah, I think I can simply do that. So if I get on Medicaid, let's say I go into a nursing home and I get on Medicaid. When I'm in the nursing home, who's paying the bill? The government is. So the government is paying my bill. And so I live in the nursing home for 3 years. The government pays an average of $60,000 a year. They put in, $180,000 into my care. I die, they want some of that money back. They want to get as much of that money back as they can. And if that means putting a lien on a house that I own that's worth $180,000, then they'll do that. So that's the whole point of the Medicaid estate recovery, is trying to get the government's money back for what they've paid out in long-term care.
Okay, what should you do if a person has been dead 5 years and their trailer home and land did not go through probate? Is it still necessary?
Yes. Yes, it is still necessary. It just makes it a little bit more difficult because technically after 4 years, you can't probate a will. You have to do it through an heirship. Now, there are ways around that, depending on what county it's in. So you need to get legal advice on it. But yes, that trailer home and the land, the trailer home, I usually don't worry about unless it's been attached to the land, because trailers are titled like a car is. But the land is got an unclean title. The deceased person owns that land, even in the grave, until something is done to transfer it. So yes, a legal process has to be done.
Okay, this is a good one.
I've done them
What?
20 years past. I mean,
Oh,
I
good.
don't mean to interrupt, but I've done cases where dad died 20 years ago and mom's been living in the house for 20 years and didn't think she had to do anything to get dad's name off the title. And now mom passes away and the kids go, wait a minute, dad's name's still on the deed. Yeah, well, we have to do a probate for dad and we have to do a probate for mom.
Okay, what do I do if I want to leave my home to my grandkids that are under 18?
You need to leave it in trust. A person under 18 cannot accept money or property at all. They have to have it held in trust for their benefit until they turn 18. And if it's not in trust, then the court will have to set up a trust at death, and that gets a lot more expensive. So yes, you want to set up a trust now with those directions in it.
Okay. Is the living spouse required to cease using a joint account that has the deceased still on it?
No. Usually you notify them about the deceased person, so they'll take them off the account. But if you're legally on the account, you can continue to use it, and you're responsible for it. So that's another thing, is if there's a joint credit card and mom dies, dad still has to pay it because dad's name is on the credit card.
Okay, I am currently setting up a third-party trust for my disabled sister that is on the Star Plus waiver program to be funded with her share of assets from my mother's death. Her money is still sitting in the estate account. Will I be able to add that to the trust for her when my father passes?
Yes, but it won't make it a third-party trust. A third-party trust means that the money that comes in is from somebody else. It's not her money. And if this is inheritance, it becomes her money. And so her money goes into it, makes it a first-party trust. So you need to get legal advice if you haven't already, because it can cause some issues. You're commingling money, it sounds like, where there's some third-party money where somebody else put money in, and then there's money of inheritance, which is hers, coming in, and they mingle. It can cause issues. So you need to talk to somebody.
Again, we have I think you've already answered this, but does the estate have to be probated if there are no assets and bank account is below 1,000?
No.
Okay. All right. Now, this is a handwritten, signed, and dated will legal in Texas. Yes, right? Didn't you answer that?
It's called a holographic will.
Okay. And now this one says, I believe MERP only applies for Medicaid members who receive waiver services. I don't know.
I don't think that is correct.
I've
never heard that. And I've done Medicaid for many, many tips. People, I haven't ever heard it being limited just to waiver services.
Okay. What percentage is required of a house sale in a Medicare estate recovery or MERP?
Okay, well, if MERP applies, so if Medicaid comes in and puts a lien, they're going to put a lien for what they're owed, and that's the percentage. So I had one in El Paso that the house was only worth $40,000. It was a little bitty 2-bedroom house, and MERP was owed like $90,000. So of course they want the whole thing. I was able to negotiate that one to where MERP took half of it. We sold it, and MERP took $20,000. And $20,000 went to the family, but they didn't have to negotiate that with us. Luckily, we were able to do that, but they want their money back, so they're going to go for all they're owed.
Okay, I think those are they're nice things they're saying. I think that's all for those now, but there are some over here.
There's you want me to start with one here while you're looking at the other ones?
Sure.
Okay, if my siblings want to keep their interest in my mom's house, I don't want to keep the house, and I don't want to keep my interest. I'm willing to not make them buy me out, but I don't want to be responsible for the cost of repairing the house while they own their portion. How should I set the interest up?
Okay, yeah, well, part of it depends on if the house has been inherited yet or not. Has mom already passed away or not? I can't tell by that question. But you can relinquish your interest in inheritance. So you can file legal documents within a probate proceedings relinquishing your interest. Therefore, you're not entitled to it and you're not responsible for it. And that may be a way to do that. This is another one I would advise getting legal counsel on.
It sounds like she doesn't want to give up her interest, but she doesn't want to. She doesn't want to keep it and be responsible for paying the upkeep on it.
What's that? Cake and eat it too. You can't have your cake and eat it too on this one. If you're going to keep your interest, you're going to be responsible for it.
Yeah.
Okay, my mother refused to leave a will because she was afraid of probate. This is good to know. I have the best story on why you should be prepared.
Well, I need to get you to give me that story and all so I can share with others.
Okay, well, what can a TOD be used for? I know the house, but what other assets could be used?
Well, and again, I don't recommend it for a house. The best place for TODs is accounts. So bank accounts, checking accounts, savings accounts, CDs, investment accounts, anything held by a financial institution is the best way to use a TOD or a POD. They work the same, transfer on death or pay on death. Those are the best way to use those.
How are a death certificate and a will placed into probate?
You have to file it with the courts. So you have to file an application to probate the will. The death certificate doesn't go to the court. It gets presented to the court just to show the prove up death, but it doesn't get filed with the court. The death certificate stays in the county of record, the county records from where the person passed.
Okay. If a person has a living trust done in Texas, is it good if they move to Arkansas, or does it have to be redone?
Yes, it is good, but I always advise my clients to talk to an attorney in the state they move to make sure there's not any special unique things about that state that they need to be aware of. And I'm not saying this because I'm in Texas, but Texas has some of the strongest trust laws of any state in the United States. So a lot of my clients keep their Texas trust because it gives them more benefits when they move to another state. But you do want to talk to an attorney in that state to make sure.
Explain again, who do we have to pay at the end? Things that can be taken away?
Okay, so before talking to legal counsel, I'm going to clarify that you don't just not pay things, but before talking to legal counsel, only pay what can be taken away or what can be turned off. After talking to legal counsel, then you'll know who else needs to get paid, if anybody.
I think we'll do one more, and then I'm gonna. There's a couple. We were supposed to go to 11:30 anyway, so we're really right on time. I've got a couple of slides I want to go over when you're done. So
Sure.
We'll do one more question.
And this is a good one. Does putting your home in a trust negate the homestead exemption?
No, not if the trust is properly drafted.
Very good. Well, I want you guys to make sure you take down Fred's information here. You also have it in the slides that I've given you the link for. This is one of the slides. I'll also be putting the link to the slides in the follow-up email that will go out here in about an hour or two. I want to make sure you're aware that if you weren't here at the beginning, the CEU, there are going to be 2 documents that are due if you're interested in CEUs, and they will go to Sheila. And I encourage you to get them done quick and get them to her and not drag that out, because it's nicer to be able to do all that together and not have to do them one at a time. The other thing is, again, we're going to send out a survey with a drawing. In our follow-up email, we're looking for your suggestions on future topics that we can bring to you. We're looking for a topic name and a description of what you'd like to see in that. We're collecting those through the end of March. You can enter as many times as you'd like. Every time you enter, your name's going to be put in a hat for, we're going to draw 3 $50 Amazon gift cards. Finally, our next month's, we're going to talk about veterans benefits. We're actually going to adjust this title a little bit, but next month on April 22nd, we're going to be talking, Haiman+Hogue is going to talk to us about veterans benefits. And so that I will have that flyer, a link to that, and the registration up before I send out the reminder, the follow-up email here in about an hour or so. I still get many questions about the recording. Yes, we're recording this. That will go out in a second follow-up email that will go out in about 4 or 5 days. But we'll send everyone who's registered for this event will receive the link for the recording. It will be on YouTube. Fred, thank you. Thank you, Sheila. Thank you so very much. We sure appreciate you all joining us today. And please, give a shout out to our speakers. You guys did a great job. Incredible information, seriously.
And thank you, Marty, for everything you do, especially for all these hardworking people out there that are on the front lines. God bless you guys. Like I mentioned earlier, I was a police officer before I was a lawyer, and I know what it's like being in the heat of it. And God bless you guys for everything that you do. Thank you so much for your service.
Thank you, Sheila. And you all have a great day.